Judgment in the matter of Travelers Insurance Company Ltd versus XYZ.
Lord Briggs will explain the decision of the court.
This appeal is about the court's power to order payment of a party's costs by a person who is not a party to the case in question. Lawyers call it a non-party costs order. The English courts have had such a power for centuries as part of the judge-made common law, and a statutory power to do so since at least 1890. But this was for many years, until 1986, not understood as going that far. The result of that misunderstanding is that the principles are not as clear as they might otherwise have been. The power to make a non-party costs order is now contained in the Senior Courts Act 1981, where it provides that the court shall have full power to determine by whom and to what extent the costs are to be paid. This appeal is about non-party costs orders against insurers. It is, of course, extremely common that insurers both fund and take an active, even controlling part in civil proceedings without actually being a party to them. This is typically because the defendant's liability is covered by insurance, such as insurance for causing injury in a car accident, or product liability insurance. Generally speaking, the victim has to sue the insured wrongdoer, but the insurer pays the amount, if any, awarded as damages. The victim does not usually have a direct claim against the wrongdoer's insurer, and so is not made a party to the claim, even though it has to foot the bill. That bill will usually include any of the victim's legal costs ordered to be paid by the wrongdoer. Turning to the facts of the case, in outline they are as follows. For several years until March 2011, a private clinic run by a company called Transform Medical Group supplied and fitted breast implants for its women patients of a type manufactured in France, which turned out to be defective because they were prone to leaking their contents. In a large group action by over 1,000 women with defective breast implants of this type, 623 claims were made by patients of Transform. The Travelers Insurance Company provided defective product liability cover to Transform, but only for the last 4 years of the supply period and only in relation to actual bodily injury. Only 197 of the claims against Transform were covered by Travelers Insurance. The remaining 426 patients had uninsured claims, either because their implants were fitted outside the period covered by Travelers, or because their implants, although defective, had yet to start leaking. But all the 623 claims were pursued together in the same group action by the same legal team on a no-win, no-fee basis, under which each claimant was responsible separately for her share of the overall costs, something called a several-only costs liability. As is usual, Transform's policy required it to fund the defence of the insured claims and gave Transform effective control over the conduct of the defence and of any settlement negotiations. In 2013, the judge managing the case directed that four test claims should be fast-tracked in order to resolve two important common issues. 2 of those test claims were by insured claimants, and 2 by patients of Transform whose claims were uninsured. This two-way split was pure happenstance, since neither the judge nor the claimants or their lawyers knew in 2013 which claims were insured, and there was no legal requirement on Transform or Travelers to tell them. But Travelers had to fund Transform's costs of defending all 4 cases, because failure on the common issue in any of those 4 cases would prejudice the defence of the insured claims. By mid-2014, Transform was in serious financial trouble. It became apparent to everyone that even if all the claims against Transform succeeded, only the insured claimants would receive any damages, let alone their share of the costs. But by then the claimants' combined legal team had spent very large sums in pursuing all the claims, so that even if they succeeded, they would only recover that part of the costs for which the insured claimants were responsible, namely the fraction represented by 197 over 623, i.e. less than 1/3 of the total. By then, Transform had voluntarily disclosed which of the claims were insured. Nonetheless, the claimant's legal team decided to continue the uninsured claims, partly for the purpose of getting non-party costs orders against Travelers if they succeeded. In due course, all the insured claims were settled in April 2015, with Travelers funding those claimants' damages and share of the costs in the usual way, as required by the policy. Transform went bust and abandoned the defence of the uninsured claims, so they succeeded as well in the sense that a financially worthless judgment was obtained in 2016 against Transform for damages and costs. Then the uninsured claimants sought a non-party costs order against Travelers. Both the judge and the Court of Appeal thought that making of such an order depended on two questions. One, was the case exceptional? And two, would making a non-party costs order accord with fairness and justice? The judge considered that the order should be made because Travelers had advised Transform not to disclose which claimants were insured when it was in a position of conflict of interest, and because Travelers had intermeddled in the conduct of the defence of the uninsured claims in certain specific respects which crossed the permissible line. The Court of Appeal considered that justice required a costs order against Travelers because otherwise there was an unfair lack of reciprocity and cost risk between the claimants and Travelers, under which Travelers would recover all its costs of funding the defence if successful, whereas the claimants would only recover the 1/3 share of the cost attributable to the insured claimants if they succeeded. This court unanimously allows Travelers' appeal. I give the lead judgment, and Lord Reid concurs by reference to a detailed history of the non-party cost jurisdiction both in England and Scotland. Lord Sumption concurs with additional reasons of his own. Our combined reasons are as follows. 1, at least in relation to non-party insurers, liability for costs does not depend upon the elusive and uncertain concept of exceptionality. Clearer principles are needed so that insurers can understand their cost risk in advance. 2, the non-party insurer's liability depends upon whether the insurer has either conducted itself so as to have become the real defendant to the claim, or has intermeddled in the conduct of the defence to it without justification, causing those costs to have been incurred. 3, where the relevant claim is wholly covered by insurance, the first of those conditions is likely to be satisfied. When the claim is covered only in part, there is already a line of Court of Appeal learning which satisfactorily develops the first condition, known as the Chapman principles, after the case in which they were originally laid down. But whereas here the relevant claim is wholly uninsured, it is usually the second of those conditions which falls to be applied. Has the insurer caused the cost to be incurred by intermeddling in the defence of the uninsured claim without justification? In the present case, Travelers' involvement in the defence of the uninsured claims did not amount to unjustified intermeddling. The extent of its involvement was necessitated by the need to deal with issues common to both the insured and the uninsured claims. The advice to Transform not to disclose which claims were insured was the exercise of a legal right and not a form of intermeddling in the uninsured claims at all, even if it may have contributed to some part of the uninsured claimant's costs being incurred. The other specific aspects of Travelers' involvement criticised by the judge, mainly in relation to making admissions in or settlement of the uninsured claims, were not unjustified intermeddling, but even if they had been, they didn't cause the relevant costs to be incurred, because they happened after the decision had been taken to pursue claims by then known to be uninsured, partly for the purpose of obtaining a costs order against Travelers. The lack of reciprocity in costs risk relied on the Court of Appeal was a natural consequence of claimants suing an insolvent, uninsured defendant in a group action with shared several-only responsibility for costs. It had nothing to do with any aspect of Travelers' involvement in the conduct of the litigation, and it was therefore, in principle, irrelevant.